Hey everybody, Zach Wolf here with another great Top 5 Tuesday. This week on Top 5 Tuesday, it's the top 5 misconceptions people have about attorney-client privilege. You may have heard some of these in the media lately. Number 5 is thinking that whether the lawyer got paid determines whether there was an attorney-client relationship. That's not really right. You can have an attorney-client relationship without the lawyer getting paid, such as in a pro bono case. The fact that the lawyer got paid could be a relevant fact in determining whether there was an attorney-client relationship, but payment of the lawyer is not the test. Okay, so what is the test? For the purpose of privilege, there will be an attorney-client relationship where, number one, the lawyer provides professional legal services to the client, or number two, where a potential client consults with the lawyer with a view to obtaining professional legal services. If either of those two things are present, you've got an attorney-client relationship, at least for the purpose of privilege. Number 4 is similar to number 5. It is thinking that you have to have a written agreement to have an attorney-client relationship. That's incorrect. You can have an attorney-client relationship without a written agreement or without anything in writing. Of course, having a written agreement could be very strong evidence that there was an attorney-client relationship, but it's not required. Number 3 is saying that the identity of the client is either always privileged or never privileged. Both of those statements are too simplistic. The general rule is that the identity of a client is not covered by the attorney-client privilege because it's not an attorney-client communication. But there are some limited exceptions where the identity of the client could be privileged. In addition to that, the lawyer's duty of confidentiality to the client could include a duty not to disclose the identity of the client. But that's not the same as privilege. Number 2 is the idea that you can cloak criminal activity with the attorney-client privilege. Well, it turns out there is actually, as you may have heard, a crime fraud exception to attorney-client privilege. So take the classic case of the mob boss who has the consigliere sit in on the meetings where they have all the important discussions, hoping that will make them privileged. That isn't necessarily going to make criminal discussions privileged. You've got the crime fraud exception. It can be difficult to apply to particular facts, but there is no question that the exception exists. The number one misconception, I think, about attorney-client privilege is thinking that all confidential communications between lawyer and client are privileged. That's not the case. The communications, in order to be privileged, have to be for the purpose of facilitating the lawyer's professional legal services to the client. So, for example, if the lawyer is strictly acting as a business advisor, those communications may not be privileged. The way I've seen some people in the media describe this is to say that the communication has to be about legal advice in order to be privileged. That's close, but I think that's a little too narrow, because you can have an attorney-client communication that doesn't involve any legal advice that is still privileged. For example, I'm a litigator. If I go to a court hearing on behalf of a client and represent the client at that hearing and then report to the client about the hearing, I may not be providing any legal advice, but my communication with the client would still be privileged. So be careful about overly broad, categorical statements about attorney-client privilege that you may hear in the press or in the media. I hope these tips have been helpful for you. Hey, thanks for watching.